Good morning, afternoon, or evening. This is Indiana University Maurer School of Law's IP Theory Journal video series, Fire of Genius. Welcome to our first ever interview for the Fire of Genius video series. I'm Catherine Morgan. I'm a current 3L and the editor-in-chief of IP Theory.
I'm Rita Shah. I'm also a 3L and the content editor of IP Theory.
Hi, everybody. My name's Emma, and I'm also a 3L, and I'm the audio editor of IP Theory.
Today, you'll be hearing from Dr. Antara Dutta. She's the principal economist at Amazon, associate editor of the Antitrust Law Journal, and co-chair of American Bar Association Antitrust Law Section's Diversity Advanced Committee. She has over a decade of antitrust experience in both the government and the private sector, having previously served as an economist at the Federal Trade Commission. She has also worked as two economic consulting firms based in Washington, D.C., and prior to that, she was the assistant professor at Georgetown University and holds a PhD in economics from the Massachusetts Institute of Technology. Today, we will be asking Antara some questions about how intellectual property, antitrust, and economics intersect.
Hi, Antara. Welcome for joining us for IP Theory's Fire of Genius. As you know, this is the first time we're trying the Zoom format, and we're really excited to speak with you today and learn about IP issues and policy from economist perspective. So I will turn over the first question to my colleague, Catherine.
Thanks, Rita. Antara, how did you first become interested in IP?
So first of all, thank you for having me. Really excited to talk about IP, which is not actually something I do a lot of anymore in a very direct way, but it's something that I've always enjoyed, and I'll tell you why. You'll find out more why it's such a favorite topic of mine. Before I get into substance, I do want to make a quick disclaimer that I have to make, that anything I say here is me just speaking in my personal capacity as an economist familiar with IP issues. So I'm not speaking on behalf of any employer or institution. So I wanted to get that out there. So going back to how I became interested. So, I was born and brought up in India, and then I came to the US for grad school to do a PhD in economics. And when you're in graduate school for economics, you're taking a bunch of courses in your first couple of years, and then you're left with this mammoth task in the next 3 years to come up with a research topic and write a paper that hopefully some people will be interested to read and will offer you a job in return for having written. And so I was always interested in, as I was taking my courses, but then starting to think about like, what do I write a paper on or dissertation on? I was always interested outside of the US in thinking about economic or other related policy issues that have to do with something international, something that affects not necessarily just India, but globally. And so this issue of IP, and more generally, and I'll keep drawing parallels between IP as a specific issue and sort of more innovation as a bigger issue, the broader issue for economists. This idea of IP and innovations always, in the background of many of the microeconomics courses that I took, that are certainly available to take in graduate school. And when I started thinking about a research topic for my dissertation, I specifically wanted to work at the intersection of development economics, which is sort of looking at the economies that are less developed today, and industrial organization, which is the study of firm behavior, of firm incentives, pricing, innovation, all of that stuff, right? And a lot of industrial organization focused on the Western world, primarily because traditionally, all the data that had been available for empirical economists had been concentrated in the US or Europe and so on. And so a lot of work had been done in that area. And so I was looking for something to do at the intersection, and a policy. I was looking at sort of what is sort of the main, what are some of the interesting policy debates going on involving developing countries or international issues. And one of the issues that was happening around, debates that was happening around then involved the global harmonization of intellectual property rights. right? And so this was largely because in the decades immediately prior to the time I'm talking about, there'd been massive globalization, and there were global trade treaties that had been signed by, on the one hand, developed countries such as the US and countries in Europe, and developing countries such as India and other countries that were not at the same stage of development as the Western countries. And they also, in addition to sort of all kinds of other economic factors being very different across these two sets of countries, they also varied widely in terms of their focus on IP rights, their institutions around IP rights, their enforcement of IP rights, and even the IP laws that were on the books of these countries, right? And so this is a really big question, and I certainly didn't have resolve any of the big issues that were underlying this question. And the big question really involved technical details around, like, what patents are, engineering, all of that stuff, legal details certainly around the law. But then there was also the economic policy debate, right? Why should we, what makes us want to have IP laws in some industries, in some countries, and not in, and have it be different in other countries. So I took on a small slice of this and delved into the pharmaceutical industry, which was very interesting and important to me, because it's an industry that both produces life-saving products, right? The drugs that they produce are really important for consumers, but also to develop these drugs, you require significant R&D expenses and time. And so IP then becomes really important. Like, how do you really incentivize firms to sink in all these resources and time into developing the technology that's at stake? So that was how I got interested in the question and the issues.
Okay, great. And so now that you've had more experience with that, how would you say economists usually evaluate the value of IP then?
So there's two sets of issues that really coincide and need to be addressed together, but I can break it up into two segments. The first is kind of the short-term issues that economists think about. So in the short term, I'm going to talk about IP as patents, although IP obviously is, I apologize for my headsets going all over my head. So IP is obviously broader than just patents. Patents is one but important form of IP. But let me just focus on patents for the time being. So in the short term, what a patent does is it essentially grants an innovator of a product or service a short-term monopoly, right? And the idea of this is that I'm giving you a short-term monopoly in order to reward you, the innovator, for having undertaken these innovation efforts that create better, improved products and services for consumers, right, and for society. And of course, there's other forms of IP that have similar effects, including different forms of exclusivity, which also give you monopoly or monopoly types of positions, right? And so when you have any kind of exclusivity right there, you immediately have what we would call an access problem, right? And what's the access problem? Which is that the exclusivity is going to lead to high prices, because you've basically told this entity that you've assured the entity that no one else can produce the same technology for some period of time. And so it leads to high prices because you're the only entity, right? Which then lowers the ability of some consumers, at least, to access the product or service at issue, right? And so you're cutting off easy access to the product just by virtue of having raised the prices for some consumers, right? And so then the short-term issue is, how do you provide access to the IP protected technologies or the products and services in which the technology is embedded at reasonable prices when you grant IP? So for what length of time, what should be the terms of the protection, and how does that affect prices and access? So that's the short-term issue. And then there's a longer-term issue that is sort of the flip side of this, which is every time you increase the prices of the innovator's product or grant them longer monopolies or stricter monopolies of some sort, you're making it more attractive for the firm, right? You're saying to the firm upfront, look, if you do this, you're going to get this in reward as a reward, right? If you undertake these efforts, right? And so you're going to tell them, so you're going to make it more attractive for the firms to invest in these projects, right? The stricter your IP is. Now, the stricter your IP protection is, the worse it is for the short-term access issues for the consumers. But what is it doing on the other side is sort of what we call the long-term goal. And the long-term goal is basically, to put it very briefly, and the punchline is we want to encourage innovation, right? So why do we need to create these elaborate policies to encourage innovation, right? Why don't firms just do it on their own? And part of the reason is that innovation is inherently can be extremely expensive, potentially very long term. Like, you could be trying to invent a new product for like 20 years, and it might take you a really long time to come up with the version that you started out trying to get. And it is also risky. You could sink all this time and all this money into a project and then come out of it at the other end with a failed product or service. You can't market it. It's not safe enough. It's not effective, and so on, right? And you don't know upfront whether it's going to work or not. So because so many R&D projects can cost a lot of time and money and still fail, you need to make innovators be assured that if they do succeed, there's something at the end of the road for them, right? Some benefit at the end of the road for them. And that's the whole point of IP protection. And in particular, in addition to how expensive, long-term, and risky these projects are, the other key factor is that economists always take into account, and policymakers take into account, is once the product is invented, how easy is it for somebody else to come in and copy it, right? If you were not to give IP protection, what would be the result? And there are going to be inherently some technologies that are super easy for someone to figure out how to reverse engineer and market, right? And others that are inherently more difficult to do that with. And so the ones that are going to be really easy to copy, and economists like to call this free riding. So the ones that competitors and other firms can easily free ride on, the types of innovations, you want to be extra careful about protecting the incentives up front. So you're basically, why is it long term? Because you're protecting it up front, the incentives up front, knowing that the actual innovation might take a while to actually materialize into something.
Okay, great. And after you've talked about those two, like the long and the short-term goals, would you say one is more valuable than the other?
So, I mean, look, different people have different views about this, but for me, like looking at it as an economist and with my sort of particular lens, I would say not really. I think, I mean, there's going to be those people who always think that people have a right over their inventions no matter what, right? But for me, looking at it in the context of these kinds of trade-offs and sort of looking at the economic cost versus benefits, I'm always weighing one off against the other. And as it turns out, that trade-off of the short-term cost of granting IP protection and versus the long-term benefit of granting the protection really does vary from product to product. And even for the same product, it can vary from country to country, right? So the kinds of questions you would ask then is, so first, when you're looking at product to product, how important is access to the new product, right? So, when you're, and I don't want to be flippant, but when you're thinking about a life-saving drug, the access issue is, at least in my eyes, different than if you're thinking about some other sort of more, less necessary, more like a leisure product or something like that, right? And so that doesn't, I mean, again, there'll be others who disagree, who will think, if you invent something, you deserve that IP right no matter what. But thinking just in terms of this lens of cost versus benefits, to me, certain types of products are where access is much more essential for a much greater part of the population. And then I already raised the question about, again, product to product, how easy is it to free ride, right? So once you know the formula of something, can you just automatically copy it, even though to come up with the formula in the first place, it took a lot of money and time. So if that's the case, if you can free write easily, again, the IP rights will vary, right? And then the short-term versus long-term issues will vary. And then of course there's the other issue, and there's also the risk and the cost and the time. And then on the country front, it also depends on the country's specific what would I call it, like the supporting institutions and infrastructure, right? So does that country have the ability to enforce or execute alternatives to strict IP laws? Can there be, can you enforce contracts well, right? That's a legal infrastructure issue, but in some countries, those are harder to enforce than others, right? Then there's also like, does the country have the appropriate infrastructure or institutions to absorb some of the costs of the patent, right? So if the cost of the patents is to increase the prices of products, okay, and you really need those products for the population, and that population is, say, there's large fractions of the population that's poor and would not be able to afford that product at high prices, does the country have the ability to subsidize, cross-subsidize, or have, in the case of drugs, health insurance or some other kind of infrastructure that helps consumers absorb the cost? So it really does depend, I think, in my eyes, very specifically on which products and which countries are at stake.
So you mentioned monopoly and price and innovation already, and we know that your work has evolved into the antitrust field in recent years. Can you give us an example where, these IP issues and policy kind of come into direct relationship with antitrust enforcement?
Yeah, it's a great question, and thank you. So there's actually a nice quote that I found once while reading about IP and antitrust, which is that antitrust and IP have always been uneasy allies. And so why are they allies? They're allies because in the long term, both sets of things, both antitrust laws and patent laws or IP laws, are ultimately based on some desire to encourage innovation and competition, right? But why are they uneasy? Because they do get to these common goals in somewhat different ways and often in conflicting ways, right? So in a nutshell, as we said earlier, IP creates short-term monopolies, right? And those monopolies provide incentives to innovate. But monopolies are often at odds with antitrust. And when you think about antitrust, you're thinking about, is there a cost to having that monopoly, and can you do it some other way, right? And then on the other hand, antitrust really wants to ensure innovation happens. Antitrust is not anti-innovation. In fact, it's very pro-innovation because it's pro-consumer. But the way that antitrust wants to ensure innovation happens is to ensure a competitive landscape where every firm has the incentive to innovate, that they know that once they innovate, they will have the ability to get ahead of their rivals and be able to get consumers to buy their products, right? So they're trying to get at it in different ways. They're not entirely conflicting, but they can run into conflict with each other in specific issues. And I'll just give you a couple examples. There's just too many to list and too many types of issues. So I'm not even claiming that these are the two most important intersections, but they are the ones that I have had most exposure to in my career. So one is in monopolization cases, right? So the monopolization case is one where you're worried that there is an entity that has a lot of has significant presence in a market, some form of market power, and is engaging in conduct that's harmful to consumers. That's the antitrust concern, right? And here, so where does monopolization intersect with IP? So you could have a patent holder who by definition has been given some kind of monopoly over some area, however big or small. And the concern might be that the patent holder, who is here the monopolist or the entity with market power, is leveraging its rightfully earned market power in one area into another area, right, where it shouldn't be able to do so. And so you could have a firm that has a patent on a pioneering technology, say a transformational technology. Everybody agrees it's a great technology and has, done great things for society. But suppose that technology requires other types of complementary services or products to make it work well, right? So you have the technology and then you've got all these other complementary elements to it. And maybe that patent holder is able to make those, has some other product or service that is the complementary, or like participates in that complementary technology market, right? But the patent holder also can purchase that same technology or make it compatible with other third-party firms. So you've got the patent holder that has its own technology, and then you've got the complementary technologies, and the patent holder has a foot in the complementary technology as well, but other third parties do as well, right? So then the question is, could the patent holder use that market power it has in its own technology to then leverage it, what we call a leveraging of market power? Could it leverage it into a different space? And so that would be one common area where this issue, and really the philosophical question there is, where does your IP right end and where does your, antitrust violation or potential antitrust violation begin, right? Another type of example is that you might have seen referenced are, and the specific issues here are vast, so I won't even go into them, but they're standard essential patents, right? And so standard essential patents involve technological standards that have been deemed to be sort of, so a particular set of technologies that come together to make something work, say the 5G network or something like that, right? You need a whole bunch of different technologies produced by, potentially owned by different firms to make it all happen, right? And you might have a technological standard that involves a whole bunch of different patents and different IPs belonging to different firms, right? And so then the question is, okay, you're allowing all these entities, some of whom are competitors with each other, right? And each own a piece of the technology that comes together to make the bigger technology work. You're allowing them to cooperate, which is a good thing, because in some ways, right? Because by allowing them to cooperate, you are allowing them to make the technology better, operate better, more effectively, make it more interoperable, and so on. But then you might also see a problem with it, which is whenever you have firms who are competitors coming together, it raises the potential for collusion, right? So there's pro-competitive collaboration between competitors for a really important technology, potentially, where all of these elements are important. But then you've got the potential for these competitors to come together and reach certain agreements that might be problematic from an antitrust perspective. So that's another area where you'll see an intersection between IP and antitrust.
Yeah, I think those examples really show us the dissonance that can exist between antitrust and IP, the pro monopoly or pro, innovation. Are there any other contexts where IP issues come into play where it might not be, readily apparent that they intersect with antitrust?
So, that's a really good question. So I'll take my own spin on the question, which is, I'll give you an example where the fundamental concepts that I just covered that are important to economists, and policymakers when thinking about IP, come into play in other antitrust contexts where you might not even use the word IP. But when I describe it, you'll see that the same types of trade-offs are really what are being evaluated here, right? So think about a vertical merger. And by a vertical merger, I mean a context where you've got a firm that is merging with an entity that it doesn't directly compete with, but produces a complementary service, say, or a product, right? So I'm going to start with an example. We'll make this easier. So say you've got a film distribution company, right? And that film distributor contracts currently at arm's length with a whole bunch of different film studios or content providers, right? And then distributes the content. And while it was doing this it was operating initially as a standalone distributor and doing arm's length contracting with the different film studios, one day it decides that it's going to merge with one of the film studios, but not but continue to deal with all the other ones as well, right? So so you're going to get a new merged entity that is the film distributor and one of the film studios that it used to contract with, but it's still continuing to contract with all the others, right? And there are lots of benefits to this kind of a vertical integration, and economists recognize those. But what's the relation to sort of innovation / IP? So one of the concerns about a vertical merger like this is that now the film distributor has its own in-house film studio, but it also is dealing with all the other third-party film studios and might have access to certain kinds of information about these other film studios' upcoming projects, innovative ideas, investments, so on, as a result of that relationship, that it might be really tempted to share with its own film studio, the one it's just currently integrated with, right? So to give it a leg up in the world or whatever, right? It's not necessary that this will happen, but it could happen. That's the traditional concern. And so why is this related to IP? Frankly, it's not, because you can evaluate this whole problem without even mentioning the word IP. But if you go back to some of the issues we were discussing earlier, it really relates to that same type of like, how do I protect the incentives to innovate off these third-party film studios while allowing the film studio to gain from the film studios to gain from its benefits, gain from the relationship with the film distributor, right? So you want the film distributors to be able, the integrated film distributor, to be able to continue to deal with the film studios because it benefits both parties, right? But because there is this risk of the sharing of, what we would call competitively sensitive information that the distributor might be tempted to share with its own downstream film studio unit now, you want to be able to protect that incentive. You want to be able to protect the ability of the film studio, the independent film studios, to protect that information, right? And not allow it to be shared with with its competitor that's now integrated with the film distributor. And the reason why this relates to the same types of IP issues is because if every film studio that was not integrated with the film distributor was overly, excessively worried about the fact that every time it came up with an idea, that idea would then be shared with its competitor, it would really chill the incentives of those film studios to invest time and effort in developing these new projects, right? So even though, and some of this can be a contracting issue or a firewalling issue, like how do you set up appropriate firewalls between what information can be shared between the film distributor and its own film studio that it now owns, or there could be contracts between the film distributor and the independent film studios on what information they're allowed to share and what happens if you have a breach of contract and so on. But not all issues can always be firewalled or contracted away, right? And so the concern that you have in a vertical merger about the incentives to innovate very much mirror all of the concerns that we talked about in the context of IP. So if you are very familiar with the IP world and understand those concerns, it's very easy to translate it over to this issue where you're not really talking about granting a patent or anything. It might be just a contracting issue or a concern about how you set up the appropriate structures, but it's the same set of issues that kind of rear their head, in this setting as well.
Okay, great. And as we've all kind of seen, the world's changed quite a bit in the past 10 to 20 years, especially with IP, and it's become more globalized as we've developed. So how would you describe some of the changes in the value of IP and how the approach to IP issues has changed in the global context?
So thanks for that question. So I think, I will use, this is also a very it's a very broad question, and I frankly not only would not have the time to answer it adequately well, but I probably don't have the full expertise to answer all elements of this. So one thing that might be, one thing that interests me about this issue of the global context is sort of taking me back to sort of what we started talking about when I was talking about my initial interest in IP, which is some of the work I did on the issue of global harmonization of IP laws, right? So one of the things that we've noticed is that the world really, as you said, has become more global and globalized, and there's a lot more trade and treaties that are now, in place than used to be the case, right? Trade over multiple types of products and services, and lowering of trade barriers and so on. So as we talked about, so one of the ways in which this is played out is in the field of pharma, which is vast and huge on its own and very important in terms of the product involved. And the details of some of the issues that came up in pharma are, easy to kind of describe now that we've set up this background on why you need IP laws in the first place. And so what used to be at the center of the global pharma IP debate used to be what are called small molecule drugs. Small molecule drugs are sort of drugs that are, they're just basically, what used to be the vast majority of drugs, which is basically a kind of product where once you've sunk significant resources into the production or invention of the product, you patent it and you release the formula. And once you've released the formula, it's really easy for anyone with some background in these things, in these issues, to reproduce the formula and come up with their own drug. Right? And different countries protected pharma IP in different ways back in the day before these global trade treaties, right? And so what used to happen is, so in my home country, in India, the country built a massive generic pharma industry built purely on this practice of reverse engineering. So often you would find drugs that were under patent in the West and sold and manufactured by a single entity being sold by as 400 firms in India. Okay, so of course that meant prices in India were low, but it also meant that whoever was the innovator wasn't really being able to earn much profit from that drug from sales in India. And in many cases, they didn't even enter the country. They didn't even try to sell. The innovator didn't even try to approach the Indian market because they just didn't want to have to compete with all these domestic generic manufacturers, right? So for a while, this was well and good, and you had these two regimes, one where countries were openly flouting, the Western IP laws, and one where the IP laws were being enforced strictly in the countries in which the innovation was taking place, right? And there was, you could call it free riding by entire countries on innovations in other countries. And it was fine, partly because the Indian companies, let me just use India as an example, stuck to their home base, and they stuck to Indian or other developing country markets where the potential for profit was relatively low when you compare it to the kind of profits you could earn from the Western countries. And in the meanwhile, the innovator got to sell its products under patent in the West, right? So people were happy doing their own things, not happy, but at least tolerating these practices, as long as the Indian companies or the other developing country generic companies kept their products in their own spaces. Once trade started increasing, right? Once there was additional and greater trade, the concern became, what if Indian companies, the Indian generic companies, right, entered Western markets where there were huge profits at stake too early? They'd already mastered the production of these patented technologies or drugs, right? They knew how to make them. They knew how to make them in large scale. They knew how to market them. They had packaged them, etc. And now all of a sudden, because of increased trade and globalization, these firms might have the ability to enter markets that they weren't operating in before, where IP laws had always been protected and in place. So then the concern became much greater once this potential was realized, because the innovators said, look, maybe our incentives to innovate weren't really coming from, the smaller developing country markets, and we were okay with tolerating it. But now that there's this new threat of these products from developing countries, these generic products entering our markets, our developed country markets, where we really need the profits from, this is a problem. This is a much bigger problem. And so that's when a debate started over how do we harmonize these IP laws, especially in the context of these global trade treaties being signed. And of course, pharma is just one one area, but it was a big area. And then there was the reverse, sort of the people who were hugely opposed to the overnight changing of IP laws, because their concern was, look, look at a country like India, there's no health insurance. There's a bunch of really poor people who need these drugs. They're buying these products out of pocket. We can't just suddenly import laws from somewhere else and put it on the books and then have a whole bunch of sick people who don't have access to drugs anymore, right? And so that's how this debate kind of evolved. And it's a very long process as to how it was resolved. I mean, there's still laws evolving today, making exceptions. There were lots of exceptions made for developing countries, right? They got more time than other countries to conform their laws. There were exceptions made about the form in which their laws needed to take effect. And compulsory licensing and all kinds of other laws that complemented patent laws. But the bigger point is, you see this playing out in other spheres as well. And I think there's a recognition that what works in one place doesn't automatically change in the other place, work in the other place. But you also need changes to make trade work and globalization work. So that's sort of the complicated answer.
Yeah, we can definitely see this getting very complicated. But it's just been so interesting to hear about all of those intersections between antitrust and IP, how this all ties into the global economy, especially from the point of view of an economist. It's just been really fascinating to hear about all of this. On the behalf of IP Theory, I just wanted to thank you so much for taking the time out of your day to speak with us. And for everyone watching, thanks for joining us, and we'll see you next time.
Thank you very much for having me.